Today's video is What is a Contract? Basic legal concepts, which helps you in real life. According to me, everyone should have knowledge about our country's laws to safeguard yourself. I am giving it to you for free. Let's get started. Good day. I'm here to walk you through a concept that is central to everyday life in the United States. Contracts. Now, you may not realize it, but contracts are everywhere. Whether you're signing a lease for an apartment, entering into a business deal, or even accepting the terms and conditions on a website, you're probably entering into a contract. At its heart, a contract is an agreement that the law will enforce, but it's much more than just a handshake or a verbal promise. Today, I'm going to break down what exactly a contract is, how it works under U.S. law, and why it matters in your personal and professional life. By the end, you'll have a solid understanding of what makes a contract valid and what to do if one party doesn't live up to their obligations. What is a contract? In the most basic sense, a contract is a legally binding agreement between two or more parties. Under U.S. law, a contract occurs when one party makes an offer, the other party accepts the offer, and something of value called consideration is exchanged. Now, it's important to understand that a contract isn't just about a piece of paper or a signature. A contract can be oral, written, or implied. But once it's legally binding, both parties are required to fulfill their promises or face legal consequences if they don't. In other words, if one party doesn't meet their obligations under the contract, the other party has the right to seek remedies through the legal system. Lawyer. For a contract to be valid under U.S. law, it must contain three essential elements: offer, acceptance, and consideration. Let's walk through each of these elements in detail. Offer. A contract begins with an offer. In legal terms, an offer is a proposal made by one party to another to enter into a binding agreement. For example, let's say you want to sell your car. You tell someone, "I'll sell you my car for $10,000. This is an offer. It sets out the terms, specifically the price and the item being sold. Now, remember that offers need to be clear and specific. If you say, "I'll sell you the car," without specifying the price, that might not be a valid offer. A vague offer can lead to confusion and, potentially, no contract at all. Acceptance. The second element is acceptance. Once an offer is made, the other party must agree to the terms of the offer. In our example, the buyer would say, "I accept your offer to buy the car for $10,000. It's important to note that acceptance must be unequivocal. This means that the acceptance must mirror the offer exactly. If the buyer says, "I'll buy the car, but can you lower the price to $9,500? That's not an acceptance, that's a counteroffer. A counteroffer effectively cancels the original offer and replaces it with a new one. Consideration. Consideration refers to something of value that is exchanged in the contract. In the example of selling the car, the consideration is the $10,000 the buyer pays for the car. It's important to understand that the consideration doesn't have to be money. It can be goods, services, or anything else of value. Without consideration, there is no contract. If you promise to give someone a gift, without any exchange of value, that's not considered a contract under the law. Contracts must involve a mutual exchange of something of value. Key requirements for a valid contract lawyer. While those three elements, offer, acceptance, and consideration, are critical, there are a few other factors that can determine whether a contract is legally valid in the United States. Intention to create legal relations. Both parties must have the intention to create legal relations. In most business and commercial transactions, this intention is assumed. However, in personal agreements, like agreeing to meet a friend for dinner, the law generally assumes there's no intention to create a legally binding contract. For instance, if two friends agree to meet for a casual dinner, it's not likely to be a contract because there's no intention to enforce the agreement legally. Capacity to contract. Both parties entering into the contract must have the legal capacity to do so. This means they must be of legal age, typically 18 or older in most states, and they must be mentally competent. A contract entered into by a minor, for example, is generally voidable at the minor's discretion. In some cases, a contract may also be voidable if one of the parties is mentally incapacitated or under the influence of drugs or alcohol. Legality of the subject matter. For a contract to be enforceable, it must be for a legal purpose. In other words, you can't enter into a contract to do something illegal. So if you try to enter into a contract to sell stolen property or to engage in a criminal act, the contract is void and unenforceable. Types of contracts in the U.S. Lawyer. Now, let's look at the different types of contracts you might come across in the U.S. There are primarily three types: written contracts, oral contracts, and implied contracts. Written contracts. Written contracts are the most common and preferred form of contract in the U.S. They are clear, formal, and provide concrete evidence of the terms and conditions of the agreement. Written contracts are often used for things like real estate transactions, employment agreements, and business deals. Written contracts are especially helpful because, in case of a dispute, you have a documented record of the terms. However, not all contracts need to be written. Some contracts, like those involving small sales or services, can be legally binding even when made orally. Oral contracts. Oral contracts are made through spoken words and are just as valid as written contracts, provided all the elements of a contract are present. However, oral contracts are often harder to enforce because there's no physical evidence of the agreement. In some cases, oral contracts can be problematic. For example, if you verbally agree to hire someone to paint your house and then they don't show up, proving the terms of the agreement in court could be challenging without a written contract. Implied contracts. Implied contracts are formed based on the actions or conduct of the parties, even if no words are spoken or written down. For example, when you sit down at a restaurant, you implicitly agree to pay for the meal once you've eaten it, even if no one directly tells you to do so. This is an implied contract. Breach of contract and remedies. Now, let's discuss what happens when one party doesn't fulfill their obligations. This is called a breach of contract. A breach occurs when one party fails to perform the duties they promised to perform under the contract. So what happens if a breach occurs? Well, under U.S. law, the non-breaching party has several potential remedies available. Damages. The most common remedy is damages. This means that the party who suffered the breach can seek monetary compensation. There are several types of damages, including compensatory damages, which cover the actual losses suffered, and punitive damages, which are designed to punish particularly egregious behavior. Specific performance. Another possible remedy is specific performance, where the court orders the breaching party to fulfill their original obligations under the contract. This is more common in cases involving unique items, such as real estate. Rescission. Rescission refers to the cancellation of the contract, where both parties are released from their obligations. This is often the remedy in cases where there's been a fundamental mistake, fraud, or misrepresentation. In summary, contracts are at the foundation of our personal and professional lives. They provide a framework for agreements, protect our rights, and ensure that promises are kept. Understanding the basics of contract law, such as offer, acceptance, and consideration, can go a long way in helping you navigate your legal obligations and protect your interests. Remember, contracts can be oral, written, or implied. And while the rules are straightforward, the details can get complicated depending on the specific circumstances. If you're ever unsure about a contract, or if you're involved in a dispute, it's always wise to consult with an attorney who can guide you through the legal intricacies. I hope this explanation has helped demystify the concept of contracts under U.S. law. If you have any further questions, feel free to reach out and we can dive even deeper into this topic. Knowledge is power, especially when it comes to protecting your rights and ensuring that the agreements you enter into are legally sound.